Welcome back to Pathways and Passports, where we delve into the hot topics involving U.S. immigration and business investment. My name is Simone Williams. I am the founder and partner at Williams Global Law. I specialize in immigration here in Washington, D.C. and Virginia.
And I am Robert Arrington. I am the corporate as well as the federal litigation counsel here at Williams Global.
Today, we're talking about a topic that most people don't expect when they file their case, and it's probably not a good scenario for them. But what happens when your case gets stuck, or in the worst case scenario, denied?
And trust us, it happens an awful lot more often than people realize. But the good news here is that you have options, and people often find themselves getting approved when they use the techniques that we're looking forward to sharing with you today.
So let's start when what happens when your case gets stuck. You submitted the application, and months go by, and even years go by where there's been no action, no update, no movement, or no explanation. And the truth is, delays happen more often and are common than you realize. It happens in employment-based cases such as 485. It happens with investor cases, investment immigration visas. It happens with family based cases, I 130s. It happens even with work permits and travel authorization application. So this happens often.
And here's what most people just don't know: a delay is not the end of the world, it is not the end of your case. And we at Williams Global have multiple tools to get it moving.
So the first option that is available is actually called an expedite request. And this is where you demonstrate that your case meets one of the expedite criteria that's been offered by USCIS. This could be a compelling government interest, humanitarian reason. This could be severe financial loss, and even clear USCIS error.
And we have had tremendous success with expedites for investors, for families, employees, as well as humanitarian cases when the petition is prepared properly. And that's where a lot of people stumble because they go to GPT, or they go to Google, or they go to their friend who's a CPA to go ahead and prepare these documents, where they need to be done in a way that is specifically tailored to be able to go ahead and get the result that you're looking for. And that can only be achieved by people who have the experience, as Simone and myself here at Williams Global.
And I just want to be clear that, to be honest, expedites aren't always granted and aren't granted often. But however, if you have a clear, compelling case that's legally grounded, the chances of your success increase significantly.
Now, we want to talk about the second one is mandamus cases. If your case has been pending before USCIS, that stands for United States Citizenship and Immigration Services. That's the agency in the US that handles immigration cases. If it's been pending before them for just an unreasonably long time, or it's become clear that USCIS is simply refusing the act, a federal mandamus lawsuit is a very viable solution to go ahead and move USCIS forward.
And I'll be honest, when people think about suing USCIS, a lawsuit, that's what is that? Is that going to jeopardize our case? It's a lawsuit against USCIS. We want to just be sure to explain that the mandamus action is really a procedural tool. It doesn't force USCIS to approve your case. It simply compels them to make a decision to get your case unstuck when your case has been pending past the statutory guidelines or pending too long. And in our experience, we've seen this with tremendous success because essentially, when you file a mandamus, there's federal court rules that says that USCIS has to respond within 60 days. So you have a defined time where there has to be some type of action on your case. And a lot of the times, USCIS does not want to fight these actions. They don't want to push back on it. And a lot of the times your case was pending too long and just needs to be unstuck for them to start processing or approving your case. So we found tremendous success with these types of actions.
And you should keep in mind that mandamus is a fancy word that simply means make a decision, right? It means that we're now telling or asking a federal court to have USCIS come before it and explain why they have delayed the case as long as they have, right? As Simone mentioned, Often USCIS or any other agency for that matter doesn't want to get in front of a judge and make that explanation, which helps to move the case forward to make a decision. One of the things that's important to keep in mind that this does not prejudice your case, right? Filing a mandamus does not mean that USCIS is going to be mad or that they're going to go ahead and file an adverse decision as a result of this. As Simone mentioned correctly, this is simply a procedural tool used to go ahead and get them to make a decision first and foremost. So it can be a very effective manner of moving your case forward one way or the other.
So it's a really great option when your case is pending for 1 year, 2 years, 3 years, or even sometimes, 6 or 8 months. In some cases, depending on the type of case, this is a very great tool to get a decision on your case.
And unlike a general immigration firm or a general litigation firm, we are a firm that specializes in these kinds of filings. And as a result, we've had very, very good success with getting favorable outcomes for our clients.
Now, let's talk about something that's even more stressful. What happens when your case is denied?
First and foremost, don't panic, right? A denial is not always final, and we have helped many clients overturn wrongful denials.
Yeah, and so we've had a great success with a few options. Now, the first, when your case is denied, you have a right to file something called a 290B appeal. However, this has to be filed within a specific period of time, and it's very quick, within 33 days of receiving the notice. And sometimes you only have a couple of weeks if you haven't received your mail.
So a 290B comes in two flavors, right? The first one is a motion to reopen. And a motion to reopen basically says, hey, there's new evidence or the law has changed in a way that is favorable to your petition. The second version, after a motion to reopen, is known as a motion to reconsider. That's where we're saying that whoever the hearing officer was in your case simply got the law wrong, and there needs to be a new analysis done on the case, which is can be effective as well.
So, what we do is that we analyze the denial, we identify any legal or factual errors in the case, and then we develop a very strategic response. USCIS officers sometimes do get it wrong, sometimes do not review the full factual record, or there's some type of error that we can hone in on to show that, yes, the denial was an error.
So USCIS hearing officers do their best, but they're humans and sometimes they do make mistakes, right? And as a result of our ability to go ahead and do an in-depth analysis, a true deep dive on your case, our track record with I-290Bs is extremely strong regarding business cases, investor cases, humanitarian cases. We've had a very, very good success record.
And so the next type of option you have if your case is denied is actually a federal court appeal. This is when USCIS issues an unfair or unlawful denial. So you have a right to challenge this denial in federal court under something called the Administrative Procedures Act, or APA.
And this is where our litigation practice comes in full throttle. Federal judges don't have to simply accept USCIS decisions, particularly when they are arbitrary, when they are unreasonable, or when they are unsupported by evidence. And this is what a lawsuit will do. It takes the decision making process out of the hands of USCIS and puts it into the hands of an impartial determinant, the federal judge.
And many times, once we file this complaint in federal court, it may reach mediation, and USCIS may come and decide to mediate or reach a settlement before it even reaches the judge.
Exactly. We've had a lot of success with our cases following federal intervention. So it is a tried and true, well proven solution, which we have an awful lot of experience with.
And finally, the last option that we would consider is actually just refiling your case with better documentation, stronger evidence, and a better strategy.
And what we do is we walk clients through which option is the most effective and the most cost efficient based on the denial reason. We will go ahead and redo the file and take a fresh look with fresh eyes with our experience to make sure that this time we're doing it in a way that presents your petition in the most favorable light to USCIS.
And to be clear, Even if you were denied, that does not mean you cannot refile your case and that you would be approved subsequently with better evidence and a better strategy. Even if your case is denied, it's completely fine to refile your case with stronger documentation, better evidence, and a clearer strategy that's outlined in the subsequent petition. Yes, your case is denied, but what we do is we inform USCIS there was a denial, but here's the reasons why it is no longer deficient. We make sure to be clear as to why your case meets the standards and the requirements to ensure success. Being able to refile your case, you have another opportunity to show USCIS that, look, I meet the requirements. And with a better strategy, with a better approach, with stronger supporting documentation, you can certainly get your case approved the second time. It's not an issue, just as long as you address whatever deficiencies were in your first petition.
And we have helped clients at every stage, whether it's pushing USCIS during long, uh, sometimes seemingly interminable delays, whether it's filing successful mandamus lawsuits or outright federal lawsuits, or whether it's helping to overturn denials through I-290B filings.
So, whether you're facing delay or denial, we here at Williams Global Law are here to help. Whether your case has been stuck or even in worst case, denied, we will help you prepare a better, stronger case to make sure we address all of the deficiencies and to ensure a successful outcome.
And remember that your case isn't over until every legal option has been explored. And that is what we are here for.
We look forward to helping you move forward. Make sure you subscribe to our channel and follow us on Instagram at Williams Global Law here below. And we look forward to seeing you again.